Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, one of the most common questions I get here at Washington Gun Law is how on God's green earth can these legislators just thumb their nose at the Constitution and pass laws that are blatantly unconstitutional? And it's a very complicated answer, but part of it has to do with plausible deniability. That is the ability to say, well, we didn't really believe that there was case law that would apply to our state that would necessarily make this unconstitutional. And we sit there and we go, no. Y'all knew this was blatantly unconstitutional. You just did it anyways. Well, sometimes it's very difficult to prove that, but I got news for you. Out here in my home state, the People's Republic of Washington, they're about to prove that point to you. I'm not joking. They are literally going to do something that they know to be unconstitutional, and yet they're going to do it anyways. So today, let me get all of you around the country educated about the state that's going to prove they don't care about the Constitution. Okay, America, here's what we're talking about today. It is a combination of a case out of California called Nguyen v. Bonta. We have been following that case. It is a challenge being spearheaded by the good folks over at Firearms Policy Coalition, which means we'll be putting links down below so that you can show them some love. This is a challenge to California's ridiculous law that you can only purchase one firearm every 30 days. So literally a quota on your constitutional right. Now, what we're also going to be talking about is up here in the People's Republic of Washington, House Bill 1132, a second attempt at Washington State that's going to try to do the exact same thing. It will also limit the amount of ammunition you can purchase in a single transaction as well. Now, let's just go back and take a look at what happened in California. You see, because California already passed this law, and it's codified in two separate statutes known as California Penal Code 27535 and 27540 sub F. And almost the minute that law went into effect, the good folks over at FPC filed a challenge, basically saying, hey, this law is unconstitutional, and they demanded injunctive relief. They wanted a temporary injunction placed on enforcement of that statute while the case was pending outcome on the merits. Now, as we know, because y'all geek out with us all the time, in order to get injunctive relief, you have to show that, one, you're suffering irreparable harm, and then number two, that you were likely to prevail on the merits. Well, the judgment from the United States District Court for the District of Southern California found in favor of the plaintiffs and enjoined that law. As a matter of fact, the order of the court read, the court declares that California Penal Code sections 27535 and 27540 sub F and defendants' enforcement policies, practices, customs, and actions related to enforcement of California Penal Code sections 27535 and 27540 F violate the right to keep and bear arms protected under the 2nd and 14th Amendments to the United States Constitution. Okay, but then we all know what the state of California did. That's right, they immediately crapped their pants and they appealed it to the 9th Circuit, which, if you are advocating for our constitutionally guaranteed liberties, you will know that the 9th Circuit is not the place to go. The state of California asked the 9th Circuit to stay that injunction. That would allow the law to go back into effect and allow California to enforce it. When the 9th Circuit received this case, they in fact stayed that injunction. As a matter of fact, the order of the court read, appellants having established a sufficient likelihood of success on the merits of this appeal and made a sufficient showing on the relative equities to justify a stay pending appeal. The motion to stay the District Court's March 28, 2024 permanent injunction and judgment is granted. But the court did leave one little thing open. In granting a stay, we do not intend to constrain the merit panel's consideration of this appeal, including whether to leave the stay in place. Well, then on August 14th of this year, the 3-judge merits panel of the 9th Circuit heard oral argument, including this argument from the state of California.
Do you believe that the Bruin analysis applies? In other words, that this regulation falls within the plain text of the Second Amendment, and then we look to a historical analog?
That's correct. That with the text and history standard that the Supreme Court has set out would apply here, and it is plaintiff's burden to show that it is at the first step that it is presumptively protected by the Second Amendment, and in this case they haven't done so because this is a acquisition of firearms, and if we just purely based on the text of the Second Amendment, it doesn't mention anything about purchasing. It's keeping and bearing, and the Supreme Court has stated that keeping and bearing refers to possessing and carrying.
But we've addressed that issue in two cases that I can think of, Tejada and B&L Productions, and described acquisition as an ancillary right. So how does that affect the analysis?
So that's correct, Your Honor. It is an ancillary right, and as an ancillary right, as B&L Productions states, it is there is some protection for ancillary rights, but it's the plaintiff's burden to provide evidence that any regulation that touches on ancillary rights would have a meaningful constraint or impair an individual from being able to exercise their core Second Amendment rights of possessing a firearm for self-defense. And in this case, we have plaintiffs that already have firearms, and they can't purchase a firearm and just have to wait 30 days before purchasing another one. So they are exercising their core Second Amendment rights. There's no dispute about that.
Do I understand the state's argument to be that the Second Amendment guarantees the right to bear an arm, that it could be just one arm and then your right is satisfied?
Well, admittedly, Your Honor, the term arms is plural. But what we have in this case are plaintiffs who already currently own arms, and so they can purchase another one. So they are exercising that Second Amendment right of possessing multiple arms. And so this
I guess I want to make sure I understand your answer. Is your answer that no, the state of California's position is not that the Second Amendment is satisfied so long as you can possess one firearm?
So the Second Amendment right is encompassed in the fact that the arms is plural.
I mean, I get the temporal argument, and I understand why you make it. What I'm trying to figure out is if you had somebody who wanted to buy a firearm, wanted to buy two firearms for whatever, maybe they have two homes and they want a weapon in both homes for self-defense reasons, which would be core Second Amendment territory, and they don't have any already, there is a period of time that the state has said you don't get to do that. And how do you balance that with, if it's true that the Second Amendment covers the right to bear more than one firearm, how does that temporal limitation square with the Second Amendment?
Now, on a side note, I don't know if the state of California kind of knew their goose was cooked and just sent some lackey down there to go argue. But if that truly is one of the better assistant attorney generals you have for oral argument, God help everyone in the state of California. Okay, but here's the deal. That argument was made on April 14th with a stay of the injunction in place. Now, the court has not ruled on the merits, but less than 24 hours after that oral argument, they did issue this order. The order granting defendant's motion for a stay pending appeal is reversed. Yeah, that's right. Here it is. That's how long that order is. So less than 24 hours after the merits panel heard whatever that was from the state of California, they lifted the stay of the injunction. The very court that had stayed the injunction has now lifted the stay, which means they clearly do not believe that the state of California is likely to prevail on the merits. Now, I can assure you, before the Washington State Legislature and our governor has a chance to put pen to paper and pass House Bill 1132 into law, there is going to be a ruling out of the Ninth Circuit that's going to say that California Penal Code 27535 and 27540F are in fact unconstitutional, because they are. And that should, if you had a constitutionally conscious state legislature, stop House Bill 1132 in its tracks. But that's not what's going to happen. No. They will push forward anyways because they are hell-bent on disarming the lawful and responsible gun-owning Washington residents. And so we're going to go ahead and link up House Bill 1132. We're going to keep you all very apprised of what's going on, because if you actually want to have Exhibit A, about how these gun control states absolutely positively do not care about the Constitution, well, Washington State is about to hand that to you on a golden platter. Listen, we'll go ahead and link up everything we relied upon down below so that you guys can geek out on it for yourself. If you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information's down there in the description box. If you got an idea for a video we should be doing around here, cool. Just click on that link right there and tell us all about it. If you want to subscribe to our monthly newsletter, the ability to do all of that is down there in the description box. And then finally, and most importantly, let's remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe. Hey everybody, Bill from Washington Gun Law. Hey, listen, I want to give a huge shout out and thank you to all of our viewers. As you know, Washington Gun Law was blessed to be named to the 5 finalists for Best Voice of the 2A coming up here later this month at the 2025 Gundy Awards. It would not be possible if it weren't for all of you. God bless all of you. Thank you so much for always geeking out with us. Hopefully we'll bring home a winner, but hey, thank you once again. Y'all stay safe.